Tēnā koutou katoa, no mai, haere mai. Welcome to the latest in our LDAC webinar series. In this webinar, we're going to do a deep dive into Chapter 4 of the legislation guidelines relating to the Constitution. In a moment, we'll talk to our panel members, Paul and Carl. But before doing that, I'd like to do a couple of things. Firstly, let me introduce myself. I'm Guy Beetson and one of the deputy chairs of LDAC. I'm also a non-public service member of the committee. My day job is General Manager Governance Leadership Centre at the New Zealand Institute of Directors, where I lead thought leadership, policy and advocacy, and as IOD's registrar, I have responsibility for director professional standards. And oddly enough, compared to our two panelists today, my background is in economics rather than law. Secondly, I'd like to introduce you to LDAC and give a bit more detail about today's deep dive webinar. The Legislation Design and Advisory Committee is made up of members appointed by the Attorney General to support good legislative design. It's a mixture of public service and non-public service members, and all of those members are voluntary or unpaid for their LDAC work. And in the case of the public sector employees, their time is loaned by their employer. The Parliamentary Council Office provides secretariat support, including advisors to support the committee. It's also fair to say that members have a broad range of backgrounds. We draw from members of legal and policy teams within departments, Crown entities, as well as academics, lawyers, barristers, and consultants. And that's necessary because a broad range of skills and experience is important for good legislative design, and it's because it's multidisciplinary. It's not just about the law. The committee has three functions. We publish and maintain legislation guidelines and supplementary material. That's Government's Handbook for Good Legislative Design. The most recent edition was updated in 2021, but the guidelines have a decades-long history and are direct successors of the Legislation Advisory Committee guidelines. We carry out education and engagement activities like this session today, but also for departments and for certain kinds of issues. Both these activities extend our reach beyond our advice functions. It's common to see submissions to select committees refer to the guidelines as well. And ministers are required to address consistency with the guidelines in cabinet papers for bills. Our advice functions apply at two different stages. The bulk of our advice work is prior to introduction, when we advise departments that come to us. And we also make submissions on relatively rare occasions to select committees. We also aim to support good lawmaking. We are guided by the guidelines and supplementary material. And I want to emphasize that the guidelines are not about policy. They're about expressions of policy in law. This means when you bring a bill to the Legislation Design Advisory Committee, you'll find us not giving an opinion on policy. It's important to remember that the guidelines in that context are just that, guidelines. These are not rules that must be followed, and you'll hear more about that in our session today. Our goal is to help ensure that conscious design choices are being made. Just turning a little bit to today's webinar, we're going to look at three areas. We're going to look at the basis of the New Zealand Constitution, New Zealand's constitutional principles and values, and hopefully provide some tangible advice for officials, which we can also pick up in Q&A at the end. I guess I should also emphasize at this point that today's webinar is not going to be a complete recitation of Chapter 4 of the guidelines. There's just too much material in there. So what we're going to do is cover the very important pieces of those guidelines, and we can explore more of the things that you're interested in as participants in the Q&A at the end of the panel conversation. So now let's introduce our panel members. Firstly, I'd like to turn to Paul Rishworth, KC. We're very fortunate to be able to draw on Paul's amazing expertise for this webinar today. Do you want to tell us a bit more about your background and experience, Paul?
Well, thank you, Guy, and good afternoon, everybody. I'm a barrister now practicing at Britomart Chambers in Auckland, and I have for a long time also been an academic at the Auckland Law School, but 9 years ago I moved to Wellington and worked for Crown Law for 4 years overall, and in the last 5 years I've been practicing on my own account as a barrister. I've been on the Legislation Design Advisory Committee since it was formed in 2015, and a few years prior to that was on the old LAC.
Thanks, Paul. And just to emphasize your academic background, but also that barrister and solicitor background as well, which I think is really important. And if we can turn now to Carl. Carl's Deputy Parliamentary Counsel responsible for system stewardship and brings for us, I think, a combination of that legal background, but also the practitioner background. Do you want to talk a bit more about your background and experience, Carl?
Yeah, thank you, Guy. So, yeah, as Guy said, Carl Simpson, I'm currently at Parliamentary Counsel Office. I've had a career that spanned policy and law in a range of roles at Ministry of Transport and MB before that, and now sit across the system trying to improve quality and access to legislation, and have been on the Legislation Design and Advisory Committee for the same length of time as Paul. So really looking forward to the discussion today.
Thanks, Carl. So before we get going, I just should emphasize, I suspect through this session and in the panel session we're going to do first, you're going to have some questions. And so please don't wait until the end of the discussion between Paul, Carl and I to ask those questions, and you can ask those questions using the Q&A button at the bottom of your screen. So that's the one that's got Q&A next to it. That'll be helpful. So now let's get going. The first topic we're going to address is the basis of the New Zealand Constitution. And it seems like a pretty weird question, but I'm going to turn to Paul and ask him something really basic, like what is the New Zealand Constitution?
Well, you often hear it said that we have an unwritten constitution, and I guess it's just taken for granted that, of course, we have a constitution, but this word unwritten is used to describe it. And I think it's interesting to unpack that. I mean, it's not literally an unwritten constitution, because obviously we've got a statute called the Constitution Act 1986, and we've got a statute called the New Zealand Bill of Rights Act 1990. And both of those deal in their subject matter with the sorts of things that you do find in constitutions. Yet the important thing about our statutes, though, is to realize that they don't really constitute anything. That a constitution tends to mean, when one speaks of a written constitution, a document that actually constitutes something. And we're used to that usage when it comes to incorporating societies and companies and so on. And if you look at the most famous constitutions around the world, like the American one in 1789, that was brought into being by a document that establishes the three branches of government, gives them the powers that they have. This is the federal constitution. And then there's a Bill of Rights attached to it by way of the various amendments that came very soon after, and that limits the powers of the federal government. So you get this constituting document, which you have to look at to see what can it do and what can it not do. But with New Zealand's constitution, if the truth is that it's actually something that arose through having been created by English institutions, the English Parliament and the English Executive, appointing governors and creating by statute a New Zealand legislature. And in the end, as you well know, the UK has disclaimed any further use of those legislative and executive powers over us. But historically, that's where it came from. And so it's left our institutions like Parliament and the executive sort of hanging free, if you like, from any foundational document. And I think this is why recent developments with the treaty are so significant and interesting, because the treaty is often said to be a foundation of our constitution, by which is meant that it sort of made the constitution possible. I mean, it was the essential reason why the English were asserting authority in New Zealand to do these things. They sort of made the idea of New Zealand possible, the treaty. And there was explicitly the basis for English law and institutions to take root here. And at the same time, the actual text of the treaty captures quite interestingly and perhaps serendipitously the aspirations that Indigenous people have everywhere for autonomy and a visible presence in the Constitution. And in a way, we're going back and we're, at this stage, I think, reimagining our Constitution. And because it's not written, it's amenable to that sort of reimagination. And that's what we're seeing now with every generation sort of making its own interpretation of our Constitution. So I guess that's my first point about our Constitution, that it's not written in that sense. But my second, and there's only 2 points, Guy, to answer, is that every Constitution, whether it's written or unwritten, reflects deep values, a sort of matrix of sort of how it came about. And you can read into a constitution a whole sort of history that's pregnant in its words. And so if you take written ones like the American one, and you look at, say, the 14th Amendment, where everyone is guaranteed the right to liberty, which can only be taken away by due process of law. You know, that's a powerfully evocative set of words. And the people that wrote that were consciously drawing upon a whole English heritage that actually goes back, even some of the exact words like due process, to the 13th and 14th century. So you really can't understand a constitution without knowing sort of where it came from and what it is actually embodying with these deep values. And I think that's why, you know, when it comes to interpreting, say, rights in our Bill of Rights, which, as we just said a moment ago, it's only a statute passed by Parliament, but there's a sense in which these deep values will not be the prisoner of the type of document they happen to be in. It's the values themselves that are significant. And so when you look at our Bill of Rights, it's no surprise how powerful and important it's come to be. And so when you get that recent case in the Supreme Court, Fitzgerald and the King, in which the court actually read an exception into the otherwise apparently clear three strikes legislation to say this will not be the law when applying it would breach Section 9 of the Bill of Rights, then what that's doing is drawing from that deep value and saying, look, this Parliament can't have meant to infringe upon that deep value just casually. It would have had to have said so if it really meant that. And in a way, that's the message of our Bill of Rights in particular, that every discretionary power, every discretion, every definition in the statute book is pregnant with that possibility of exceptions to preserve rights. Why? Because they're part of the constitutional matrix, even of New Zealand, even with an unwritten constitution.
It's an interesting point you've made, though, and what you've said, Paul, kind of makes me think in terms of, you know, people often talk about constitutions having imperatives for government and having constitutional restraints on government. That's kind of really interesting words. What do you, when you look at those things and you think about that construction of thinking about a constitution, what do you think that means?
Well, the way I've really come to see it is this, that the 20th century has been the sort of language of human rights, has very much occupied public law and constitutions. And it really comes back to the 1948 Universal Declaration. But if you look at the rights in that, a lot of them are the economic and social ones: the right to health, the right to education, right to welfare, and so on. And it's increasingly seen that these are rights as well. And so I see that the idea of rights is and always has been a sort of imperative. You know, it's why governments do things. It's why parliaments do things. There are a lot of good reasons for passing laws. And if you actually look at the laws and the titles in our statute book, you see things like health, education, workplace safety, welfare, social development. And you look at the names of our ministries, that's what it's all about. So I guess the first point is that our parliament and our executive are the branches of government that sort of do things, always for, we hope, for good reason. We don't hope, I mean, it's true. Every political party has its own vision of what's a good thing to do. On the other hand, the civil and political rights are like restraints, and there are reasons that really counsel against doing things in a certain way. And both are always in play. There are good reasons for education, statutes and health, and so on and so forth. But we take it for granted that when decisions are made about people, that natural justice will be observed. We take it for granted that when a crime is created, there will be a fair trial. So every statute is actually pregnant with all these constitutional concerns, whether they are constraints, you know, not doing things. And also every statute is explained by a positive imperative to do something good.
Yeah, that's really useful, and a really useful way of just unpacking all of those things. But one of the things I'm intrigued by in terms of what you said, Paul, is just the kind of the values base and the historical base and that kind of building up and layering. And I do think there's an element, I think, when policy advisors and legal advisors are kind of starting to think about policy and translating that policy into legislation, they almost need to get into a constitutional mood in some senses. So I thought I might turn to Carl, and given your vast experience on both sides of this at some level, how do you get into a constitutional mood as you're starting to think about that policy and translation into legislation?
Yeah, thanks, Guy. I think it's actually relatively easy as policy advisors and lawyers to stand in the shoes of the executive, because that's whose interests public servants most directly serve. But I think when sitting in LDAC, we see that as a trap that leads agencies to miss or make mistakes about constitutional issues, particularly the role of Parliament and the executive and the courts. And I think I sometimes encounter sentiments in my job and in my previous roles that could, if I was being uncharitable, be characterized as the executive trying to keep other branches out of the way of the policy decisions that executive has made. So I think one key point here is to try to consciously change your perspective. So for primary legislation, I try to look at that from the point of view of a Supreme Parliament, which Paul talked about just before. Recall that parliamentary sovereignty was a concept that was hard won through revolution, and it's a position that we should expect Parliament to jealously guard, even that sometimes when it doesn't appear to be jealously guarding itself. But as advisors, we should be expecting Parliament to jealously guard that right, particularly in relation to other branches of the government and also to international bodies and things like standards bodies as well. So from at least from the point of view of legislation, Parliament is supreme. And it might lose that position someday, but as I said, it shouldn't be expected to do that lightly.
It's interesting too, as you said that, Carl. I think what occurred to me was that those people involved in supporting legislation and supporting select committees when a bill's in Parliament from a departmental perspective see that up front and personal, really. And I just wonder whether there's any more kind of practical tips you've got for achieving the objective you're talking about, and just in terms of making sure that the parliamentary piece of this is seen in the way you've described.
Yeah, it's easier to see when you're actually in Parliament. It's a bit harder when you're actually developing the policy or designing the legislation at that earlier stage before you get there. But I mean, so just some ideas that I was thinking about is, first, what's Parliament's perspective on legislation? So in here, you should be focusing on the fact that Parliament is the body that's legislating. It's determining what the obligations of citizens or visitors to Aotearoa will be, what the scope of the law is, who will take action under it, and where the requirements that it's setting will be enforced. In other words, lawmaking is not Parliament approving government policy. It's not a rubber stamp, nor is it really a scrutiny function. And if Parliament, and this sometimes happens, if Parliament wants to go its own way on legislation, then that's a matter for Parliament and not a matter that it has to get approval from the executive to do. Then another thing when you're designing legislation is to consider the legislation in light of the means that Parliament usually uses to achieve its objectives. So one thing Parliament often decides is that it can't or shouldn't work out all the details itself. And so in those cases, it delegates the details to someone else through secondary legislation, but always under its oversight. So it's delegating that function to someone else. And you need to think about secondary legislation as, within that context of delegation. It might recognize that some of its requirements might not work in all circumstances. And so it wants to set the general rules, but it might need to leave some scope for those to be modified around the edges. So it might provide for exemptions from the general rule, through a delegation of a lawmaking power on a class basis, or even old administrative powers to exempt. And then it might say no one can do this thing unless they are given a license from an official or from a body. And it might then often it will specify what contraventions are a matter of the King's peace, and so enforced through the criminal law, through the criminal courts, and what are matters for private dispute, matters that are really a matter for citizens to work out between themselves. And the guidelines talk about this quite a lot. And then it might also establish bodies that are accountable to it, either directly or through the executive. And it might adjust, if there's good reason, the role of the courts or provide for alternative means of enforcement. But it will do that on a really conscious way. And so that's how you look at legislation from that perspective. And then the last thing that I think about is that Parliament is in an ongoing discourse with the other branches, not really a conversation, more a discourse. So in the case of the courts, you have to look at, is Parliament seeking to override other significant laws, such as the New Zealand Bill of Rights Act 1990, or give expression to the treaty? And if it is, why is it choosing to do that? And how is it choosing to do that? And is it doing so in clear enough terms that the other branches of government will recognise? And in the case of the executive particularly, has it put the right guardrails in place, either on a general basis through its scrutiny function, or in a particular oversight on things like through the Regulations Review Committee or through criteria, in order to ensure that the policy that Parliament is adopting through that legislation is adhered to. So, overall, legislation is a means of Parliament ensuring good governance. It enables Parliament to trust the executive, that the executive will carry out those functions that Parliament has given to it, and that and provide for citizens to operate within parameters that Parliament expects.
That's certainly something to look out for. And it's interesting just drawing the threads together from what you've said, Carl, and what Paul said earlier. Interesting to find that we're one of a limited number, possibly only 3 countries with the constitutional arrangements we've got. That notion, and just drawing that thread together again, the notion that constitutions, and our constitution in particular, reflects public beliefs and values and that evolution over time. We're not going to deal with all of that today, but it's certainly worthwhile those participants on the call and those who they support thinking pretty actively about how that evolution is happening and the fact that it continues to happen. The idea that you're actually sort of learning all the time, that there's no kind of fixed view of what this constitutional framework, well, the framework kind of doesn't really change, but things that happen within it certainly do. Just want to remind people that if you've got questions, please ask them using the Q&A button at the bottom of the screen. Be really helpful to pick those things up. Now we're going to turn to constitutional principles and values. And I just might turn to Paul again, because it's one of those things where you kind of look at these constitutional things and you say, well, actually, surely there must be some sort of legal test we can use with these constitutional matters. What's your view of that, Paul?
Yeah, that's a good question, Guy. I mean, is there some sort of legal test for what is a constitutional matter? And it's so much easier to see that, I guess, when you're looking at a written document. But actually, it's not that much easier, or should I say, it's not that much more difficult to see these things in the New Zealand context, because the truth is that I think it's useful to see that there are basically 2 sorts of constitutional question. And the first, I think, corresponds to structural or institutional issues. And the second, just to foreshadow it, is the rights of individuals or human rights. But if you think of first of the constitutional issues that surround our constitutional structure, I mean, you see it in some important cases in our past. Now, back in that time of the Economic Stabilization Act, when we had wage freezes and price freezes, all those things in the 70s, that was when, you might remember that if you were a public lawyer, that Lord Cook of Thorndon came out in a series of cases saying, maybe there are some things that go so deep in our constitution that even our so-called Supreme Parliament can't take them away. And one of his examples was, what if Parliament delegated all its legislative authority to one person on a topic, or for all topics? Would that not be just abrogating the role of Parliament? Do we imagine our constitution actually envisages something like that? And it's a very, very wise question. I mean, his other example, of course, was some human rights go so deep, like torture, that if Parliament purported to authorize it, then we couldn't accept that that was a valid law. But I was interested in the fact there are those 2 types of questions, the structural ones and the human rights questions. And the structural ones are actually all around us, and they really are in the list that Carl just went through. These questions like, when does something belong in secondary legislation, or when should Parliament delegate to somebody else to make laws on a certain topic? And could you delegate laws that allowed your delegate even to make laws that overturned acts of Parliament? Now, these are all things that do happen. So it's not as if there's a strict constitutional rule against them, but I guess the point is you are in constitutional territory when you are doing that. And same with another of Carl's examples. What role do you have for judges in your new policy, your new legislative scheme? And I think we'd all agree that there's a sense in which having a judicial branch means there must be something that it does, a core judicial function. And if you had statutes that just reached in and took things out of what judges do, and then at the end of the day said, oh, we've still got a judiciary, but it doesn't do the things that a judiciary does, then you'd be asking big questions about your constitution. But again, these are not simple rules. They are constitutional sort of questions, and there often isn't an easy yes, no answer to them, but they happen more often than you would think. And those are the sorts of questions that LDAC gives advice on to make those sorts of judgments. Another example is, when should legislation be retrospective? And that's a difficult question, and sometimes there are good reasons why it should, and often there's reasons why it shouldn't, but they're not sort of yes-no questions. They're matters of judgment. And if Parliament is acting in a retrospective sense, it can shade into taking over the role of judges. And so it's those structural questions that are in play. When you look at the human rights side, then I think the constitutional questions tend to be a bit more well-defined and have sharper edges, because we are used now in our system to the question, is something consistent with the Bill of Rights or not? That's a legal question that ultimately courts can answer. And so far as LDAC is concerned, in the drafting of legislation and the guidelines, obviously that's a heightened concern. Does this legislation actually authorize people to act so as to infringe rights? It wouldn't be the job of LDAC to give advice on whether that yes-no question is answered yes or no, but because that's known to be the job of the Ministry of Justice or Crown Law advising the Attorney General. So I guess our message, when the constitutional concern is a human rights one, is just, have you considered that? And sometimes it's best to consider that now and get a definitive answer at this earlier policy stage, rather than leave it hanging so that it becomes a problem later on. So that's my answer, I guess, Guy, to your question of how do you decide what's a constitutional matter or not. I think it's useful to think of those two types.
Yeah, it's interesting too. As you were talking, Paul, I was just thinking about, often we're confronted with a conversation with departments about, say, the removal of judicial review. And that fits into your first category, not the second one. And and they are questions of judgment. That's one of the reasons why we have useful conversations in LDAC subcommittees considering bills on questions exactly like that. And I guess if I can turn to Carl briefly, there's a whole range of principles and values that sit behind all of this, and some of that also relates to the treaty as well. Do you want to just talk briefly about the kind of core principles and values you think are relevant to this, bearing in mind there's a whole range of others of those values and principles embedded in what's in Chapter 4?
Yeah, so you already touched on consistency with the treaty as a core part of our constitutional makeup. So Chapter 5 sets out guidelines to support agencies to work through that consistency, and LDAC often provides additional assistance to agencies. Often where that advice is where the legislation is trying to give life to the principles or the treaty itself through legislative provisions, and so we support agencies to work through those matters. There's also as well as LDAC, there's also the Treaty Provisions Oversight Group, which provides valuable insight and advice to support consistency of approach, which is a key challenge in a really an evolving constitutional area for our society. And then there's also the recent Cabinet Circular to guide. And then stepping beyond the treaty, we've got, there's the principle that legislation should be consistent with the dignity of the individual and presumption in favour of liberty. That's a whole group of rights, including matters like the right not to be deprived of life, and freedom from discrimination or physical liberty, and freedom of conscience, religion, and other matters. And then also procedural fairness, or natural justice. And the expectation is that legislation will be construed and applied in light of these and other abiding values. And of course, most of those fundamental rights and freedoms have since 1990 been affirmed in the New Zealand Bill of Rights Act 1990. So, I don't want to go through all those in detail, but there's a lot in Chapter 7 and Chapter 6 and other chapters around there about how to work through these matters of constitutional significance.
Yeah, it's interesting, right? I mean, in the sense that there's a lot of principles and a lot of values that sit behind it. That's one of the reasons for having Chapter 4, because it actually starts to work through that, not almost necessarily in a checklist type fashion, but certainly to some extent with that. And you've made the point that Chapter 4 overlaps with some of those other chapters in the legislation guidelines. So really important to get to grips with that. You don't have to remember everything in our webinar today, and we haven't covered all of those things. But useful to be reminded of that and have a bit of those kind of core principles and values rehearsed. I think it's worth, before we turn to our last section today, in terms of tangible advice for officials, just sort of remind people we've got a few questions already. We're looking for some more if people have those as we go forward. But I think it's worth talking a little more about what tangible advice we have collectively for officials. And I wonder if we can just turn back to you, Carl, as a starting point, and then we'll go to Paul after that. If you were thinking about common constitutional issues that you've had to deal with both in your legal advisor hat, but also wearing your policy hat, what sort of things would you point to in terms of the stuff you've had to deal with?
Yeah, so I'll take a couple at this moment. So I think one of the most challenging things that as legislative designers we face at the moment is a question of how overrides of fundamental rights are done and how clear and unambiguous the wording needs to be in order to achieve a policy objective. So, without a clear intention for application, the courts will presume that general words in legislation are intended to operate consistently with constitutional principles and values. And that's a challenging and sometimes unpredictable area for agencies. And it's, as I was talking about before, it's subject to ongoing discourse between Parliament and the courts. And Paul talked about in the Fitzgerald case about, that's a new change. And there was also the fairly recent High Court decision about the 501s, which went both ways on that question about clear and unambiguous wording. So that's a key challenge that is evolving, and and something that requires thought and probably looking at it from a few different angles. The other thing I'd like to cover now is one of the things that I'm particularly interested in, which is the allocation of functions and roles. Who's the right person, and this is a question of who's the right person to allocate a role to when Parliament isn't going to do it itself. So, and the choices are things like, the King and Executive Council, a Minister of the Crown who's got portfolio responsibility for an area, so he has a policy interest. It might be a technocrat, a public official or regulator that is established and overseen for the purpose of carrying out their function. It could be to the courts, who are experts in adjudicating on disputes and giving life to those basic principles. And it could be another person, could be a private entity, it could be, heaven forbid, a foreign entity. But these things do happen. And the key point here is that Parliament needs to be making those decisions, and legislation and advisors need to be making those decisions carefully with a clear understanding of the person's role and capability and accountability. And we should be thinking, is this the best person to carry out that role? And what gives Parliament the assurance that they're likely to perform that role that Parliament expects?
Yeah, it's interesting, eh? And that's so often comes up in terms of designing new entities or changing them or whatever. So that's the officials piece of this to some extent. I'm going to turn to Paul. And it seems to me that we don't want the legal advisors to miss out on some practical tips as well. And some of that comes down to the common constitutional issues that arise when it comes to legislative proposals that lawyers have been involved in. What are some of the common constitutional things you've seen in legislative proposals, and particularly things that have sometimes caused issues?
Well, I think one that we see a bit at LDAC and also see it in other statutes that don't come through LDAC is what you might group under the subject of retrospective legislation, where legislation is passed that sort of affects the past in some way. And I guess there are there are two rights in the Bill of Rights that have a bearing on that, and that's Section 25D, which is that you've got the benefit of the lesser penalty if the penalty is changed on something you've already done, and Section 26, which is the right not to be convicted for an offence which wasn't an offence at the time of the act. So those are in the criminal sphere. But I'm thinking more broadly about the things which change the law for the future and affect civil cases or the civil rights of people. And I guess the paradigm is, say, like the validation of something that's been declared unlawful. Now, in our Legislation Act, there's a broad principle against retrospectivity. It just says legislation shall not be retrospective. But then, of course, as that excellent book by Burrows and Carter says in the next sentence, when quoting that, says, but that in fact, of course, legislation can prevail over the Legislation Act, and that presumption can be displaced by clear words. And when you think about it, even deciding whether something is retrospective is a matter of opinion or even technique. So that if you, for example, were to say, well, from now on, no court shall enforce a contract of this type, then you are really saying something about the future, but you're really killing off contracts that have already been made. And you don't have to say this applies even to contracts in the past, but your prospective legislation has that sort of backward-looking effect. And that's always been the thing about retrospective legislation. It's sort of just hard to define. And sometimes legislation affects the past in ways that we would think, of course it does. Like if you bought your house in a school zone, which gives it extra value, and the next week Parliament abolishes school zones, then there's been some impact upon your previous decision, but most of us would say, well, that's just tough. That's the way life is. So there's a spectrum for retrospectivity. So I guess what that means for thinking about it is it's not really a strict legal question that has a yes or a no answer to it. And I think sometimes people would like there to be one, because then you can say, oh, well, the lawyers said it was okay. But a lot of it isn't like that. And so that's one of those constitutional sort of structural questions, as I see it, where you need really to think things through, and that's something that I think LDAC has assisted on in the past. It's an interesting also that there are questions about whether, in fact, there is a right in the Bill of Rights that relates to that, so that it is a legal question, so that, for example, in the case about the validation of the Mangawhai District Council's illegally struck rates, the argument was accepted, at least at first instance, and by one of the judges in the Court of Appeal, that validating the subject matter of existing judicial review proceedings implicated Section 27.2 of the Bill of Rights, the right to natural justice, that you've got a case on foot, but there's been legislation which in fact dictates the result. And but that just takes you into the Section 5 of the Bill of Rights, because there can still be reasonable limits on your rights. And so that would be the disciplined way of thinking about an issue like that. Was it reasonable for that to happen? So that's an issue that I think we see quite a bit of, and I think there's a structured way of approaching it.
Yeah, it's interesting, right? Because two things occur to me out of this conversation. One is there is a level of mythology, which hopefully the experienced practitioners involved in the webinar today realize, that the law is not quite as static or as black and white, even if it's written down, as people might think. And that's more than just interpretation. And you've both pointed to quite a number of things which kind of butt up against the constitutional piece of this in all sorts of ways. And I suspect some of our participants and others who they support they may feel like they're a bit alone. They can read the chapter 4 of the guidelines, I guess, but you've got a really interesting question around that. So I guess the first thing I think we should say is that the policy advisors and legal experts who are providing advice on this stuff aren't alone. there's Legislation Design Advisory Committee clearly, but the treaty provisions group as well that Carl mentioned, the Ministry of Justice with Bora, and there's a whole range of others. There's also some quite useful literature, and particularly would point to a short essay by the Right Honourable Sir Kenneth Keith entitled On the Constitution of New Zealand, Introduction to the Foundations of the Current Form of Government. Those things actually start to help. And I think you've usefully both pointed to some things for people to look out for, but that's a kind of a non-inclusive list. You've pointed to a couple of 3 examples across all of that. So I think we'll just move